court. But the issue is this: what is a dispute? And when does a dispute arise? A dispute is only mentioned in section 41. In fact, the legislature assumed that a dispute is an English word, which would naturally it's not a special word. In its natural existence, a dispute arises when somebody is aggrieved or somebody controverts issues that are against him. Until that, there is no dispute. There couldn't be a dispute by NEC. NEC cannot have a dispute by itself. It's not logical. But when the subjects of NEC decision are aggrieved or complaints on a certain set of facts, then that is a dispute. That is when and only when a dispute is determined.
And then it says that then it gives the jurisdiction under 41 determination of disputes and how disputes are done. So the manner in which my senior went, I think it will be the first time I've had that submission. But that being the case, a dispute cannot be by the persons who are making the administrative action of the party or the organ that is making it. It cannot be. And so I want to stop there, but I urge you that this is not an academic case. It is never an academic case. This is about people, about political rights, about people who are in the countryside who do not understand the meaning of scintillar evidence. These are people who just want to enjoy their political rights. So when a person puts himself beyond the reach of others and he occupies a position that therefore disentitles others, this tribunal has jurisdiction, and I think that is why the legislature created this tribunal, to be able to balance the rights between an individual and the thousands of Kenyans who would wish to exercise their rights. I thank you.
Okay, thank you, Mr. Kajwang. Senior Counsel Okero on Rejoinder?
Yes.
Oh, sorry, Mr. Okero. Mr. Wakoko, sorry. I almost forgot Mr. Wakoko.
Thank you, Honorable Chairperson and members. Thank you so much.
Yes.
Honorable members of the tribunal, we responded to the application and the appeal by filing our response in the style of a replying affidavit. It is sworn on 18th February 2026. Chairperson, it is our position that we have been invited to court prematurely in the sense that under Section 40 of the Political Parties Act, the Register of Political Parties has not made any decision that could make a party member or a political party for that matter drag the registrar to court. So, Honorable Chairperson, as the tribunal retires, I invite the tribunal to look at Section 40, and further, I invite the tribunal to look at Section 20 of the Political Parties Act in terms of the change of party particulars, which it is our contention that we are not in receipt of that particular change, and as such, no decision has been made. I rest at that, Honorable Chairperson.
Okay, thank you, Mr. Wakoko. I apologize. I almost forgot you because you said you have no dog in this fight. That's why I was almost forgetting you. We now can go to the rejoinder by Senior Counsel.
Thank you. Thank you very much. I'm just organizing my notes here. Yes. Honorable Chair and members, Mr. Makori began, first of all, by unfortunately completely misconstruing the submissions I made in relation to who the aggrieved party was. My submissions are not questioning who the aggrieved party is in this case. Submissions were questioning who the aggrieved party was in relation to the allegations of misconduct raised against the complainant, Secretary General of ODM. In fact, this actually ties in with the closing remarks made by my learned friend, Honorable Kajwang. Because, as he very helpfully pointed out, that it would be a fallacy, that it would be incorrect to claim that organ conducting administrative proceedings is the complainant. And yet, looking at the affidavit of Halima Daro, which disclosed the particulars of the allegations raised, the only source of allegations that the complainant has, and it is being raised by an official of the party on behalf of the party. It doesn't name whom the allegations have been made by. And so therefore, the irresistible conclusion is that it could only have been members of the NEC who were aggrieved and made allegations of misconduct against the complainant, not disclose them until 10 days after the resolution to remove him had been passed. My learned friend, Mr. Makuri's reference to Article 88 of the Constitution does not assist the first respondent in any respect, Your Honor, for the simple reason that provisions of Article 88 and its reference to internal dispute resolution mechanism do not operate to cure ultra-virus actions, any party official or any party organ. Article 88 of the Constitution of the ODM is only useful and invocable where it relates to proceedings under the Constitution of ODM that are lawful. Mr. Makori has submitted that the resolution of the 11th of February 2020, which purported to remove the complainant, came up in the agenda as a matter arising. Honorable Chair and members, that is a statement made from the bar. There is no evidence that they have produced to confirm that this was the case. On the face of the resolution itself, nothing suggests that it was a matter arising. Evidence before the court, including the text messages from the executive officer notifying the NEC members of the meeting, speak for itself. There was absolutely no notification, even to the members of the NEC, that there would be any deliberation under Article 74 on the conduct of the complainant. Mr. McCurry has stated that Article 74, Sub-Article 3 of the ODM Constitution provides the complainant with a right to be heard. That is true, but what he is avoiding, Article 74(3) places an obligation upon the NEC to notify the complainant prior to the making of any resolution. It is the NEC's breach of this sub-article by failing to notify the complainant prior to the resolution resulted in the NEC's proceedings being rendered an illegality. Council has also referred to the internal appellate architecture, which he claims has not been invoked. Here again, I must repeat that the only foundation of this submission, the doctrine of ostrich equivocation. No reference whatsoever has been made to any provisions of the ODM Constitution relating to this internal appellate architecture. Because, with respectfully submit, there are none. Once the NEC makes an executive decision under Article 74, Sub-Article 2, results in the removal of office of the person who